Good morning. Almost good afternoon, but not quite yet. Welcome to round two. I don't believe that Mr. Bacon, I don't know if I'm on a close enough basis with Mr. Bacon to call him by his first name, but it does not appear that he has made a response video. However, in the responses that I've seen, he is exhibiting, he is telegraphing his next plan of attack. Now, I don't believe he's actually going to address any of the things that I've stated, any of my arguments directly. I think he's going to try to present his own case, but that's fine. I will deal with him on that. His big gun. This is his big gun right here. It's Genovese versus the town of Southampton. This should not be his big gun. I have seen this case. It is the only case that is published on 18 USC 795, and it only deals with it almost tangentially. It's the only one out there, and that's why he found it, and that's why I found it. The difference between us is I ruled it out as being of much consequence, if any, and he thinks that it is somehow, I don't know, a magic bullet. Maybe I shouldn't say that, but he does think that it really bolsters his case. And it is it is something that I would throw out there if I was on his side, obviously, because it does appear to support his position, but it's a very weak support. And I'm going to explain to you why it's a weak support. First, you'll notice that it is a district court decision. It is not a circuit court decision. Now, in the federal courts, you can cite published published district court decisions, but they are at best persuasive. They are not precedent, which means that no other court has to follow this particular judge's interpretation. The Honorable Joseph F. Bianco is now, as of 2019, he was appointed to be a circuit court judge, but he wrote this 6 years ago, 6 years before he was a circuit court judge. So there you go. The second big thing you may want to note is that this is a civil action. You have a plaintiff and you have a defendant. This is not a criminal action. Now, 18 U.S.C. 795 is a criminal statute with criminal enforcement mechanisms. You can do up to a year in jail. I don't remember exactly what the fine was, but you could do up to a year in jail and pay the fine, or both. So it is a criminal statute with criminal penalties for violating that criminal statute. And of course, with criminal statutes and criminal penalties, you have a higher burden of proof. It wouldn't be a plaintiff, it would be a prosecutor would have to prove beyond a reasonable doubt all the elements of the crime are met by the facts. And that is not what is happening here. This is a civil case, and the burden of proof in a civil case is preponderance of the evidence, which is 2 steps below reasonable doubt. There's clear and convincing that's in between. So it is a much lower standard of proof. Preponderance of the evidence just means it's a 51-49 split. So that's a big difference. And the third thing that you may want to notice, or maybe it's the fourth, I don't really know or care at this point, is that the United States of America is not a party to this. So those are 3 big things. And then, of course, the fourth thing is that this just deals with probable cause. Now, it holds that there was probable cause for the plaintiff's arrest, if it was in fact an arrest. And it says it basically doesn't have to determine whether or not it was a detention or arrest, because the court holds that there was probable cause for an arrest. So the problem with that, if you're trying to say that the statute, that the elements of the statute were met in this case, and in this case, just so you guys get a quick fact pattern, Genovese was driving on a public road outside of an airport that was a dual-use airport. It was a commercial airport and a U.S. Air Force base. And Genovese was taking pictures of the fence line and the building. there's something about a recently restored helicopter or something like that, but I'm not sure exactly how that plays into it. An off-duty officer saw this going on. An off-duty police officer, not a federal officer, saw this going on. Detained or arrested Genovese for violating 18 USC 795. And then the sheriff ended up arresting her. The sheriff showed up and arrested her for trespass. Now, the sheriff lost the trespass case pretty hard. I think she got $700,000 because the sheriff arrested her for trespass when she was on a public road. So yeah, cops can do some dumb shit sometimes. Why the fuck they would have arrested her for criminal trespass on a public road is beyond me. But I guess, there are stupid people everywhere. But here's why it's not terribly convincing. Arguable probable cause exists when a reasonable police officer in the same circumstances and possessing the same knowledge as the officer in question could have reasonably believed that probable cause existed in the light of well-established law. It is inevitable that law enforcement officials will, in some cases, reasonably but mistakenly conclude that probable cause is present, and we have indicated that in such cases, those officials, like other officials who act in ways they believe to be lawful, should not be held personally liable. So if he could have reasonably believed that probable cause existed, and he could have, because he could have misinterpreted what the difference between an installation and a base is. Now, as to figuring out whether or not in this case, it does say that 18 U.S.C. 795 was violated. And it says 18 U.S.C. 795 was violated because plaintiff's counsel did not even offer an argument as to why it should not apply, which I think is terrible, but, it's what happened. Let's see, somewhere in here, it says, all right, here we go. In fact, when the court permitted supplemental briefing on this issue, this is the 18 U.S.C. 795 issue, following oral argument, plaintiff's counsel was unable to explain to the court why Section 795 would not apply to the plaintiff's conduct. See letter by Nancy Genovese, August 18, 2012, ECF number 54. After a careful review of this matter, including legal research and discussions with Your Honor regarding oral argument, we respectfully wish to advise Your Honor that there's nothing to oppose the applicability of 18 U.S.C. 795 in this matter. Now, here's where... Well, let me say one more thing. There is... the court also hedges its bet. So it also says, in the alternative, the court concludes that even if probable cause did not exist, Iberger would be entitled to qualified immunity because reasonable officers could disagree over whether there was sufficient basis for plaintiff's detention, given the uncontroverted facts described above. So that's not a really good hedge of the bet. But the other thing that you need to remember is that in order for qualified immunity, in order for qualified immunity to be pierced, it has to be a well-established law. It has to be something that that a reasonable officer, a reasonably well-informed officer would know that you can't do, which is, if you remember back in the Turner v. Driver case, the court found that it wasn't established law that you can't detain someone just for filming a police station in public without something more. So this case, 18 U.S.C. 795, this statute certainly isn't well-established law because this, Genovese v. Town of Southampton, is the first and only published case that references it. So obviously the plaintiff's counsel couldn't find anything on it. And why they gave up on this, I don't know. Maybe it's because they got their fistful of gold, their $700,000 from the other part. They just didn't want to fight anymore. I don't know. Because they did recover from the sheriff. This is just against the officer. So they recovered from their $700,000 from the sheriff, and maybe they just didn't want to fight anymore. But this isn't based on a constitutional analysis of 18 USC 795 to see whether it is on its face invalid or as applied invalid. And the court didn't have an opposition to the defense's position that 18 USC 795 was in fact controlling and was being violated, or there was probable cause that 18 USC 795 was being violated because the plaintiff's attorney didn't oppose it. So this is not a very convincing piece of data. It is in support of Mr. Bacon's position, but it is not convincing for all of those reasons. And if you don't agree with me, that's fine. Until a court actually sinks its teeth into it and looks at someone photographing a base that is restricted access, until a court does that and looks at it and renders a decision on those facts with the beyond a reasonable doubt standard in place, we're not going to know. We're not going to know 100% for sure, but my legal argument is, I think, much better. Now let's continue my legal argument. He's tried to say that, well, first of all, he tries to bring in Army regulations. Army regulations are irrelevant. Army regulations are policy and they affect personnel. They affect personnel and they're basically policies that apply on military property. But they don't affect statutes. The courts aren't going to look at Army regulations to determine what a statute means. They may look at the intent of the legislature, but they're not going to look at the intent of the Army. The Army was authorized to do these things under, I think, like 50 USC something or the other. I don't really know. And that was codified, or that was put in place under CFR 32 CFR something or the other. 32 CFR deals with, maybe it's not 32 CFR. Yeah, 32 CFR is national defense. So it would have been codified somewhere under there, how the regulations apply, etc. But it's not controlling over either the statute or the executive order. Obviously, the legislature it's what the legislature intended that is controlling. And on an executive order, it's what the president intended that's controlling. But there is still a difference between restricted access and restricted information. And you may notice that this is, we're back in Executive Order 10104. 10104, where it defines the military naval installations. This is about dissemination of information, right? This is 18 USC 795. It's required protection against the general dissemination of information thereto. The President defines certain vital military and naval installations or equipment as requiring protection against the general dissemination of information relative thereto. It's not access to them. You know what? A tank, a non-classified tank that is maybe older, that's in the that's with the National Guard or something like that, an older model that doesn't have the top of the line latest stuff in it, just something that's at the back of the warehouse, just on a oh shit basis kind of tank, is probably restricted access, even though all of the information about it is publicly known and available on Wikipedia. But the military still has a vested interest in not allowing people to get inside of a fucking tank because they could do damage to the tank or to the building or to a lot of things. So there is a distinction between restricting access and trying to restrict the dissemination of information relative to naval installations or equipment, military or naval installations or equipment. And you may notice that, again, now, this is the actual text of the executive order. Now, therefore, by virtue of the authority vested in me by the foregoing statutory provisions and in the interest of national defense, I hereby define the following as vital military and naval installations or equipment requiring their protection against the general dissemination of information thereto. This is about the dissemination of information. Okay? Now it does say restricted in here, but this is about the dissemination of information. A naval base isn't designated, marked, or classified as information. So this is 32 CFR section 2001.1. We talked about this executive order the other day. This part is issued under Executive Order 13526, classified national security information, the order. So now this is talking about information again. It's about the dissemination of information. Section 5 of the order provides that the Director of the Information Security Oversight Office shall develop and issue such directives as are necessary to implement the order. The order provides that these directives are binding on agencies. Section 6.1a of the order defines agency to mean any executive agency as defined in 5 U.S.C. 105 or any military department as defined in 5 U.S.C. 102. Mr. Bacon keeps asking me why the Army regulations restrict access. They designate certain installations as restricted. Well, they're talking about access because this is information. Classification is for information. So, and military department is 5 U.S.C. 102. That does list the Army, of the Navy, Army, Navy, Air Force. So there you go. And it tells you what parts are relevant to what, and that's great. But it is binding. It is binding. And remember, this does get rid of classification levels. There's top secret, secret, and confidential. No other terms shall be used to identify United States classified information. Information. These things which are now classified, designated, or marked under the authority or at the direction of the president as top secret, secret, confidential, or restricted. Now restricted doesn't apply anymore because this is a 1940 executive order. The newer executive order, this is from 2009. This modifies. Things can no longer be classified as restricted. Classified as restricted. They may have restricted access, but they can no longer be classified as restricted. Why do I have this tab up anyway? Oh. Yeah, this 50 U.S.C. 3164 classified information means any information that has been determined pursuant to Executive Order 12356, which has been succeeded by 13256 to require protection against unauthorized disclosure, and that is so designated. So, one last thing I want to point out. This is a sign. This is a sign. You can see the attachment points, which was presumably attached to the outside of a military base. And this sign, which was presumably attached to the outside of a military base, if Mr. Bacon's interpretation is correct and it actually applies outside, it can control your activities outside of the base, which would be the only time I've ever seen a sign tell you what you can do outside of an area, but okay. Then photographing this area or its activities are prohibited. Well, this appears, Mr. Bacon, to be a photograph from that area. Does it not appear to be a photograph of that area? Oh, look, photography is prohibited without specific authorization from the commander. This appears to be a photograph, Mr. Bacon. And there was no previous authorization of a commanding officer. Was there, Mr. Bacon? And there is no intent requirement, so it's just going to be general intent, right? Just taking the picture. Just taking the picture would be enough to make you culpable for up to a year in prison or a fine. But here's the problem, Mr. Bacon. Under your interpretation, if this is just taking this picture, under your interpretation of 18 U.S.C. 795, sir, it would be a further crime. It would be another misdemeanor, sir, to reproduce, publish. You're publishing it, sir. You are publishing this picture in your video. You, sir, under your interpretation of 18 U.S.C. 795, would be currently in violation of 18 U.S.C. 797. I hope you can see how retarded your position is. It is absolutely retarded. And I want to once again reiterate that while I strongly doubt a restriction like this would be a time, place, or manner restriction, I strongly doubt it would be. It appears to be a blanket restriction on speech. You cannot photograph this base from the outside, from anywhere, from a skyscraper, from outer space. You can't photograph it without the specific authorization from the commander. This appears to be a blanket ban on speech. And if it is a blanket ban on speech, it would not be a time, place, or manner restriction. It would be strict scrutiny. Not intermediate for the time, place, or manner, but strict. Which would be it would require the government, again, to have a compelling reason to ban the photography. A compelling reason. And considering that photographs of the base are captured on every dash cam of every car that drives past that military base, and considering that every military base, the outside of which, at least that borders roads, has been photographed by Google vans up to the point where it ceases to be a public road, and sometimes even onto the base itself up to the gates. There is no compelling reason for the government to prohibit photography there. Those pictures are out. There is no compelling reason. Any actual top secret, or confidential information would be tucked away behind those gates and those walls. There is no compelling reason. Any restriction, any blanket restriction on speech under the strict scrutiny analysis has to be the least restrictive. And that means that if the government can take a step of erecting a barrier to prevent that whatever they need not filmed to be not filmed, then the government has to take that step, as opposed to restricting the right of the people to take a photograph of the fence line of a base. Now, Genovese didn't address that, but it would be addressed. And I would be happy to take any case where the defendant was going up against the government for a violation of 18 U.S.C. 795, where the defendant had not stepped off the sidewalk onto what is clearly designated as base property. Once they step onto base property, absolutely, all this shit kicks in. You can't photograph without the authorization of the commander because there's a sign saying that you can't photograph without the authorization of the commander. Once they step on that base property once knowingly. I mean, it has to actually be a clear demarcation that they're on the property. It can't just be, well, the base extends all the way to the curb. No, if there's what appears to be a public sidewalk, then grace will still apply. Once they step onto the base, this kicks in. Before that, no, it does not kick in. And I would happily defend that. I would be super confident in defending it. I would have no problems arguing this out in front of a district court or superior court if it went into a state court for whatever reason. I can't imagine it would, because it is a federal law. But a circuit court, that's the word I was looking for. I'd be happy to argue it. This is easy peasy lemon squeezy, both as a First Amendment issue and as the text of the statute issue. So anyway, I wish you the best of luck. You need to get away from your Army regs, because the Army regs, posse comitatus act, sucker. It doesn't apply to me. It doesn't apply off base. Army regs apply to military, maybe just the Army. I don't know what capacity it works because I don't play around with the with Army regs. But it would not apply to a civilian who is off base. So there you go. Thanks for watching. Have a great day.